Hello, everybody! Happy New Year! Yay! It's 2023. Can you believe it? And it's already what, like January 25th? Like it seems like January just flew by, right? Well, I hope that your new year was blessed and that you get to spend time with family and friends. You get a little time to relax. I want to tell you a secret. I was going with my family to Vancouver Island for the holidays, right? So I'm working away, and I decide, I don't know, for some reason, my little finger was drawn to the Delta app on my phone. And I punched it, and sure as shoot, guess what popped up? Your flight is canceled. You can contact us to reschedule. Reschedule for what? Reschedule for when? Are you kidding me? So, yeah, Vancouver Island did not happen this Christmas, which was actually probably really good because it wasn't the weather over there wasn't that great. So, who knows when I would have been back in Florida. But hey, I got to spend time with my family. I got to spend time with my friends. And really, that's what the holidays is all about. So I hope that's what you got to do over the holidays. I hope you didn't have that stress that I had during the holidays. And then New Year's came. Now, I don't like to say resolutions because what are resolutions? I don't even know what a resolution is. But most of the time, when people make resolutions, by now, January 25th, people have abandoned them. I like to say my visions. What are my visions for 2023? So I hope your visions for 2023 are full of, health, happiness, prosperity, and just, having a great 2023. So I'm glad you're with me, the first live of the new year. Remember, we have to be writing 2023. Yes, I've had to stop myself a couple times because I've written 2022. Yes, I admit it. So it's okay. That's what we all do, right? Anyway, I'm so glad that you could join me today for my live. I thought since it's a new year, 2023, and people don't have resolutions, they have visions, right? And hopefully, one of your visions is to make sure that everything is taken care of as far as your health and your finances, that in case something happens to you, there's somebody there. So that's why I decided this month I was going to do kind of estate planning. We like to call it estate planning, planning for those kind of things. So that's why I wanted to start the new year. They were talking to me, oh, maybe do something regarding criminal stuff like that. I go, well, I don't want to start out the new year with something like that. I want to start out with something a little more productive, a little more, not to say that criminal cases, of course, are not productive, but just something that, that we can help with their visions for 2023, right? So, anyway, that's why I decided on these topics. I hope that you get a lot out of it. I hope that you get a lot of information. Please feel free, grab your little notepad, grab your pen. Although I've heard that grabbing a notepad and pen is kind of archaic these days, that generally we can do our notes on our phone. I've seen people even reading their readings at church or whatever on their phone. So I'm more of a write it down kind of gal. So I like to write it down. I like to put everything pen to paper. I have a notebook. Let me show you my notebook. It's very large. It's that, remember these different subject notebooks? That's what I like to write things in. And I like to categorize them in different subjects. So I have those 3 subject notebooks. So, yes, I'm an old fashioned kind of gal, but I'm older than the average person. So, anyway, again, welcome, welcome, welcome. And the good thing about it is newscaster Sterling is back in action. Hi, Desiree. How are you? I'm so glad that you could join us. I hope you get a lot out of this. But I wanted to let you know, like I said, newscaster Sterling, she made it apparently to her destination, wherever that was. And she got to spend the holidays because remember, she wasn't here the month of December. We didn't use her the month of December because she was off, gallivanting. But she has some pretty shocking news. I mean, it's pretty common nowadays with everything that's going on. So what I'm going to do, we're going to start. We're here. I hope everybody's settled in. They've got their soda. Hello, August. Hello. Happy 2023 to you too. You look beautiful with your friends. Looks like you had a great time. So I want to make sure that you're settled in. You're ready to listen. We're going to take our time. We're going to go through each subject. Please, if you have any questions or comments, feel free to throw them up. I am throw them up. Throw them in the chat. Throw them up, right? Throw them in the chat. I'm going to answer them throughout. They're going to post them so I see them right away. We're not going to let you kind of hang out and then you're like, what was my question again? Hi, Paula. How are you? So we're going to answer it as we go along. So make sure you have your pad, your pen, whatever you use to write things down, your little soda or your water, maybe a little nosh, a little popcorn or something to help you get through this. And hopefully you're in a comfortable area where you can just kind of take in what I'm talking about. But first, we've got some news from Attorney Sterling that I want you to listen to. So take a good listen, and I'm going to pass it to Attorney Sterling to do the news. Hello, I am newscaster Sterling, and I have the news. What we found is there's been some heartbreakingly evil people out there, and a fraud ring has been shut down. A nationwide operation used a grandparent scam to steal from more than 70 people. What they did was they would call people, random people, and say, "Oh my gosh, I'm your long lost grandson. I'm put in jail. I need bail. Otherwise, I'm gonna stay here for the rest of my life." They were doing that. And then unbeknownst to these individuals, they were worried that was their grandchild or potentially their unknown grandchild, and they would send money to these people. In fact, Timothy Ingram, the leader of the operation, was sentenced to 9 years in federal prison for stealing nearly $2 million from grandparents, including at least 10 residents of San Diego who lost more than $300,000. He was ordered to reimburse these victims. Also, Jack O'Warnor was sentenced to nearly 4 years in prison in order to repay $434,000 to his victims. How these victims did it was they would wire transfer this money and then never see it again. It more or less depleted these individuals' assets and their life savings. In the United States, over 467,000 people reported to the Federal Trade Commission in 2021 that they've lost or been defrauded of over a total of $1 billion. Also, there was a couple jailed for fleecing Medicare. They had a string of health companies and they were milking people's Medicare. What they were doing was they were billing people's Medicare who were either deceased or in prison for services that were not rendered. And they collected over 21 million in doing this scam. And a majority of it was used to, guess what, pay for personal items. The one individual purchased a $3.5 million home, and another person opened a small business with that money. So please be careful. If any advice, please be careful when you're confronted with issues or you get a strange phone call or a strange email. Please be careful and please make sure that you check it. Thank you so much. Attorney Laura, back to you. See, told you that was shocking. That's crazy. People nowadays just want to scam, unfortunately, and sometimes they do. So that's why, and I agree with newscaster Sterling that you should check. You should always check when you get an email, when you get this call, when you get it, is to check it and check with others. If it's a grandchild, if they're pretending to be your grandchild, call your grandchildren and say, "Hey, where are you?" Just make sure that you know who you're talking to and it's the right thing and that you protect yourself. That's what we're here for, is to protect you and to make sure that things are taken care of, because there's bad, but there's also good in the world. So anyway, thank you so much, newscaster Sterling. Let's move forward. Okay, again, today's live is a good thing to do now that we're in the new year. Plan out your life. Make sure things are taken care of so that if something happens to you, not just death, but something happens to you, maybe you become incapacitated for some reason, that you're covered, that you have these documents, that you can feel comforted that things are done. So, the first thing I want to talk about is what we call a power of attorney. Now, doesn't that sound kind of funny, that title? I'm giving somebody the power as an attorney. No, that's not what it is. A power of attorney means that you're giving somebody the power to take care of your financial issues. So let's say you have a bank account, you have a mortgage, you have life insurance. That individual, you're giving them that power to deal with those issues. They can call the bank and say, "I have power of attorney by Laura Sterling, and I'd like to provide that to you so that I can have access to her account to help pay her bills." Or calling the mortgage company and saying, "I have power of attorney. I would like to send it to you so that I can deal with the mortgage company. Maybe there needs to be a refinance or something like that. Or maybe the house needs to be sold and you have to deal with the mortgage company and the realtor." The power of attorney is what let's say me, I'm going to use me as an example. I'm giving this, let's say. I'm giving my mother, brother, sister, whomever, power of attorney over me. I'm doing it while I have my faculties. I am totally competent to be able to know what I'm doing. Yes, I want my brother, sister, cousin, whatever, to be my power of attorney. I'm signing that power of attorney freely and voluntarily. Nobody's forcing me to do it. I'm not confused and I don't know what I'm signing or I don't know anything. I'm appointing. That is the only way a power of attorney can be appointed, is if Laura Sterling appoints them, not just me, but if you appoint that power of attorney. Nobody else. My brother cannot appoint my sister to be my power of attorney. It can't happen. It just can't. I seem to get that a lot in my office, though. And I don't know if you know this, but FYI, I used to work as a social worker in a nursing home because I'm a licensed social worker. So I worked in nursing homes for many years before I became an attorney. And I have seen lots of power of attorneys where I'm like, no, this is not right. You can't do this. You can't have somebody else appoint for them. The individual has to be competent. Now, understand, and this is very important, when you appoint somebody as your power of attorney, it becomes valid the moment you sign it. So it needs to be somebody that you trust, somebody that you know won't go in and rob you blind. Like, oh, hey, my neighbor, Susie. Yeah, she seems like a real nice person. I'm going to appoint her as power of attorney. You sign on the dotted line. All of a sudden, you go to your bank the next day, you go in your little app or you go on the computer and you've got this much in your bank account. And you call the bank, and the bank says, well, your power of attorney, Susie, came in and she said you needed the funds, and we gave them to her because she has power of attorney. So you want to make sure it's somebody that you trust. Now, there's different types of power of attorneys. There's a regular power of attorney where it's just a generalized power of attorney, giving somebody power to do different things. We have I think it's like a 5-page power of attorney where it covers a lot. Mortgage companies, if you want to sue somebody, if you're participating in a lawsuit, all of that kind of stuff is included in there. So the difference, there's a durable power of attorney as well. There's a regular power of attorney and a durable power of attorney. The durable power of attorney means that even if I become incapacitated, I'm unable to really understand what's going on. Maybe I'm in a persistent vegetative, whatever, that power of attorney still survives my incapacity. So that power of attorney can still be there. A regular power of attorney may be just for specific things. For example, I think I've told you this before. My brother was stationed in Germany. He wanted to sell his house here in the where I'm from, Minnesota, the great state of Minnesota. He wanted to sell his house there. Well, it's kind of hard when you're across the pond to be selling items or dealing with brokers or real estate agents or title companies and all of that. So he gave my parents a specific power of attorney just to sell the house, just to deal with the selling of the house. Once the house was sold and everything was done, boop, 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 that power of attorney is no longer. It's void. So they can't take that power of attorney later and go, oh, I want to get into his retirement account, or I want to, no, it's specific. It states specific language. Well, hi, Marissa. How are you? I like your background. I love the Disney. Believe me, as you can see by my Facebook, I'm always at Disney, aren't I? I must just have a little apartment there, you think. But anyway, Attorney Laura, are there risks involved in giving someone a power of attorney? Exactly. Just what I'm doing. Marissa, you read my mind. Thank you for the information. And thank you for the cue. Yes, there is. Because like I said, you're trusting that individual that they do what they're supposed to do. As a power of attorney, you have a fiduciary duty, but if there's nobody really monitoring you, what could happen? So, like I said, it really needs to be somebody you trust. You know that you can trust. You know that they'll do what they need to do, whether you have capacity or whether you don't. So, make sure, even sitting down and talking to somebody and having that conversation with them about the power of attorney. So, just make sure that it's somebody you trust. Sometimes families who we trust, sometimes not, but sometimes we do. So we want family, or maybe it's just a very good friend that you've had that you trust, that will take care of things, will make sure that you're protected. Just make sure you have that conversation and just remember that it becomes valid once you sign it. Now, the next thing we'll talk about, and please, even though I'm moving on to the subjects, if you still have a question about something that I've already spoken about, please feel free. Ask me the question. That's fine. I have no problem in going backwards. This is all about you, and I want to make sure you get what you need out of this. Okay, so the next subject is healthcare surrogate. Well, what is a healthcare surrogate? We know what surrogates are, right? I mean, surrogates, like when it comes to child rearing, oh, well, the surrogate has a child. But no, no, no. Healthcare surrogate means it kind of is that somebody kind of steps in and makes healthcare decisions for you. So sometimes you can put that healthcare decision making in the power of attorney as well. And you can make it a medical and a financial power of attorney. But sometimes you want a separate form, and that's okay. It doesn't matter either way. A healthcare surrogate, where I'm capable of making that decision. I'm capable of naming a healthcare surrogate. So, Laura Sterling, I appoint Susie Joe, my cousin, to make healthcare decisions for me if I'm ever unable or unwilling. Now, does a healthcare surrogate come in effect when, like today, if I were to sign one? Because I seem pretty competent right now. You never know. But I'm pretty competent and I can make my own decisions, my own healthcare decisions. So the healthcare surrogate becomes valid, but it doesn't kick in until you're unable to make those decisions. So at this point, I'm able to make my decisions. So the doctors or whatever the healthcare provider is will say to me, Miss Sterling, you need to have eye surgery. Do you consent? Here's the pros, here's the cons, all of that. And they look for me to consent because I can make that decision. So nobody can come in and override my decision. So Susie can't come in and say, well, I have healthcare surrogate and I don't think she should have it. The doctor would be like, well, I'm sorry, who are you? I'm able to make my own decision. The healthcare surrogate kicks in when I'm unable to make the decision. If I come in, I've had a horrible car accident and I'm unconscious, I maybe whatever happened and they need to make an emergency medical decision, they're going to go, who do we go to? Because Laura Sterling can't make that decision right now. Who do we go to? Okay, then the healthcare surrogate can come in and say, here, I have the document, go ahead with the surgery or whatever you need to do. They will look to that person for consent until such time, if ever, I'm able to make my own decisions. So, again, Marissa, I'm going to go off of your question because it was an excellent question. Are there risks involved? Yeah, there are. I mean, you really need to sit down and have a conversation with the person that you're appointing as healthcare surrogate. Why? Because you need to be on the same page. If if you want to, hey, if I'm ever in a persistent vegetative state, I don't want to be kept alive by any extraordinary measures. But the person you're appointing is like, no, no, you're going to be kept alive, you're going to be hooked up to all kinds of machines, you're going to get everything. Is that the person that you want as your healthcare surrogate? Probably not. Not to say they're good, but they're a good person, they're a bad person, whatever. Just you have differing views. So you want to make sure that it's somebody that you trust to make those decisions. And sometimes it's hard for that person to make the decision. Everything's going on right at that moment. And maybe it's a loved one, it's a parent or God forbid a child or somebody, and you just can't make that decision at that point. You got to make sure that they're strong enough to make those decisions because there can be some pretty, life sustaining or life, ending decisions they have to make. Oh, Noelle, I think that's how I say your name. If I butcher your name, I'm so sorry. I'm so bad at names. So, but I'm glad that you joined us. I have a question, please. Does surrogating equal delegating all my medical decisions, or can I set boundaries? You can do whatever you want. Very good question. Excellent question. You can do whatever you want. If you want to put in that healthcare surrogate when and if they make decisions, what those decisions should be, that's 100% up to you because it's all about you. And even if you want to talk to them, but even talking to them and they'll say, oh, yeah, I agree. Oh, yeah, that should happen. Yep, I agree. I'll do it. Make sure it's in writing. Make sure it's in that healthcare surrogate. And we'll get to the living will in a second. So I'll talk more about that. So you're kind of jumping ahead, but that's okay. But you want to make sure that healthcare surrogate is on, and that if you only want them to make certain decisions or whatever, that you put that in writing. Because I love watching Judge Judy. I'm a Judge Judy fan. Judge Judy, if you're listening to me, I'm a big fan. She always talks about the contract. It has to be in writing. So think of these items as contracts. These are contracts that you have with that individual, and everything should be spelled out in that contract because the court is not going to go, or whomever, the doctors aren't going to go, oh, okay, I'm reading this document, that this one-page document that is delegating you authority to make medical decisions. And that's what I have to, what do I have to rely on as a medical professional, that that's what you wanted. But suddenly, if this person who you've delegated is starting to talk about things outside of this document, the healthcare professional is going to be like, I'm sorry, all I have is this document that says this, and I can't do that. And I can't tell you, how many times is my many moons, because I'm 1,000 years old, my many moons working in the nursing homes where I've had just such issues, and it just breaks my heart. For example, I had one woman that had signed a living will. She didn't want to be kept alive by any extraordinary measure. She signed it when she was totally competent and had witnesses, notary, all that kind of stuff. And she was terminal. She was coming to her end of life. And her family presented to my office saying, no, she didn't know what she was doing when she signed that. I don't want that to be enforced. I want everything done. And I'm like, no, she signed it. She signed it. That's what she wanted. And I don't know what happened when she signed. I don't know. It was signed before she came in our building. If she maybe had a conversation with her family, maybe they would have, been more aware of what she had wanted. Maybe she did, and they just changed their mind. But you got to make sure that the person you appoint is strong and can hold that and can fight against the rest of the family that may be, fighting against them. So, but yeah, that family was really fighting tooth and nail to just null and void that living will, get rid of it. Everything should be done for her. And that's a sad situation because we as individuals are able to make our own decisions. And she made that decision when she was able to make it. And she was hoping down the road that it would be honored by whoever had it. So it was really kind of heartbreaking. And I had another one too, where the woman was in a persistent vegetative state, had a healthcare decision maker, appointed the healthcare decision maker. She had signed everything, and she had signed her living will, all that kind of stuff. And I was looking through the medical record, and all of a sudden I see in the medical record a letter from the power of attorney saying, I null and void the living will, do everything. And I call her and I say, you can't do this. This is something that she decided, way back when she was able to make that decision. These are her wishes. You're just honoring her wishes. No, she wouldn't listen to me. So, just make sure, like I said, it's somebody you trust and that you spell it out. So excellent question. So, Lucas. Lucas Marcos. Very nice name. Good afternoon, Miss Sterling. Is it true that the person that has to do an estate plan before, how does it work? Well, when you say an estate plan before, the estate plan would be before, while you're alive and while you're capable of doing it. So yes, you need to do it while you're alive, while you're capable, and while you're able to do it. So, the best way I always say is to get with an attorney and sit down and go over everything. I spend a lot of time when I sit down, very lengthy amount of time sitting down with my clients when they come in for estate planning, because I go over everything that you have, all the scenarios, and finally what you want to do. One time I think I was in for like an hour and a half with somebody. And by the time I came to, well, this is what we can do for you, they were like this. They were so exhausted, but I break it down step by step. So it's something that you really need to do. I also give homework as well, because I want you to kind of clear things up and clean things up and make sure everything's set. Because sometimes we have life insurance policies that are out there and we kind of forget about them, right? I bought it like 20 years ago. It's still out there. And we've designated a beneficiary, and I've had to do this. And the beneficiaries passed away, but you forgot about that life insurance policy. So, you forget about it. Well, then you pass away. And then guess what? There's this life insurance policy out there for however much. Let's say it's, $20,000, which is a nice amount of change. Now, we don't want the insurance company to keep that, right? So I've actually had to go through probate, and we'll do a whole different, maybe I'll do that next month is probate, to go through court to get the next of kin to get that life insurance policy, where life insurance policy should just be paid right out to you. So, those are things why you should do it now. And kind of, like I said, I go over it, I give you a worksheet, all of that kind of stuff. So, we get to know each other on an intimate level, right? Because we spend a lot of time together. But good question. Anyway, okay. So that kind of leads me right into a living will. So I get a lot with a living will. Well, a living will, and I want a living will because I want to leave my property to so and so. And I have to stop and go, wait a minute. There's a big difference. There's a big difference between a living will and a regular will. But let me explain to you what a living will is first. Like I said in my video on my live, a living, think of it, living, you're alive, living will, think of that. Living will is I'm alive and it has to do with my body, has nothing to do with any of my assets or anything I may have or anything like that. Has to do with just my body. What do I want done with my body if I'm ever in a terminal condition, a persistent vegetative state, and there's no hope of recovery? What would I like done? Do I want everything done? You do everything you possibly can. Hook me up to every machine known to man so that I can maintain. And maintain is about all you would do, because for a living will to come into effect, it doesn't come into effect the day you sign it, unless you wouldn't be able to. You'd have to be in a persistent vegetative state. But the day you sign it. So again, I'm totally capable right now. I'm totally capable of signing a living will right now. This is what I want done. And sometimes in the living wills, we appoint the healthcare surrogate in there rather than doing a separate healthcare surrogate. But again, that's up to you, because if you want to put special parameters in there, like my other question asked, then you want to do a separate healthcare surrogate. But the living will says if I'm three things, at least here in the state of Florida, this is what we do in Florida. Remember, if you live outside of Florida, please get with somebody in regards to the laws in your state or your country. But a living will in Florida has three criteria. You have to be, again, persistent vegetative state. That's a fancy term for you're in a coma. Persistent vegetative state, there's no hope of recovery. You're not going to come out of it. Like maybe it's your brain is not functioning, your heart's not functioning, whatever it is, and you're in a terminal condition. Now you're thinking, who decides that? Who decides that? My family decides? No. In Florida, it has to be two physicians. Two physicians have to come in and certify that you're in a persistent vegetative state, there's no hope of recovery, and you're in a terminal condition. Two physicians have to come in independently and see you and certify that. Once that's happened, then the living will goes into effect, meaning, okay, you're just going to be kept comfortable, you're going to be kept pain-free. And that living will can be as general or as specific as you want it to be. Well, I would like to be kept on a heart machine for 24 hours, whatever it may be. But the least amount of care you'll get is to make sure you're pain free. If that means giving you, medication through an IV, whatever, and making sure you're comfortable, making sure that, your end of life is comfortable for you to pass. So that's what a living will is. A living will has to do, remember, living your living body, your body. What are you doing with it? And again, you have to be competent to be able to sign that living will, understand what you're signing, and know what you're signing. So, and again, talking that over with your family and your loved ones. Remember, you want everybody to know, okay, this is what I did, so that when it comes time, that they know what your wishes are. They know what your wishes were at the time. You don't want somebody coming in, no, 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 do everything. And you didn't want that. What I always tell my families is I say, talk to that individual that you want to appoint to make the healthcare decisions or your power of attorney, and tell them, reassure them and give them the permission to do this. Tell them, you're not making the decision. I'm making the decision. You're just following my decision. That's what you're doing. You are making sure that my decisions that I'm telling you about what I want done with my body, my money, everything is what I'm deciding. You're just enforcing that for me. So it's not you making that decision because sometimes people have that guilt feeling about it like, oh, I can't take them off the machine. Oh my gosh, that would be horrible. No, you're not. It's I made that decision. I made it when I signed the paperwork. So, alrighty, so that's a living will. Okay, now let's move into wills. Whew, let me take a drink here for a second because this is a lot that I go through. This is like a consultation with me. So, hi, August. Hi again. Oh, you and your friends. You're so cute. Attorney Sterling, once I've made a living will, very good question. What should I do with it? Excellent question. Any of your legal documents. Let me tell you a story. And I know if my parents are watching, they're probably going to kill me. They kill me every day, so no matter. But anyway, they had their documents. And I said, oh, okay. When I got licensed as an attorney, I was like, okay. Where are these documents? Well, they're in the safe deposit box. Okay, well, who has access to the safe deposit box? Well, we do, my parents. And I go, oh, okay, that's good. But what if something happens to you? What about, who can get in? Oh, so they appointed my brother. He tore on although I don't think they have safe deposit boxes anymore, but they may, because this was quite a few years ago. But if they do, they made my brother as a signer. So if anything happens, my brother can go in rather than my brother having to go to court and get an order to get into that safe deposit box, to have to drill, because this is all very expensive. Having to drill a safe actually had to do that in a case. So it's very expensive. So they put him as a signer. Great. So you could do something like that. I don't know how safe deposit boxes are now. I used to have one and then they told me they were closing it. I don't know if they were just closing the branch, but you might not check on that. Or you keep it in a safe in your house, but making sure that somebody has access to them. That somebody, oh, I got it in a safe. All right. Okay, I'm good. Well, nobody can get into that safe. So you need to make sure that somebody can get in. Or you just keep them in your desk at home. Keep them in a drawer, tell people. You can give copies. What I would do, when we do our whole will signing, estate planning document signing, I always at the end, okay, we've got all the originals. I say to my clients, how many copies do you want? Because they're going to give copies maybe to the power of attorney, to the healthcare surrogate, to their children, whatever. How many copies do you want? So we make copies for them, however many copies they want. I get a copy, they get the originals. I never keep originals. I never will keep the originals because you will need, at least with the will, when I talk about a will in a second, you're going to need the original of that. So I don't keep the originals of any of my documents. I give them because that's for you. Hey, I could be dead and gone, or my office blow up, or the computer crash and I lose it. And now I don't have the original anymore. So I don't want that responsibility. When I first became an attorney, there were many times that I had to call attorneys and say, do you have the original? Oh, yeah, let me check. It's in my garage. They keep it in their garage. So they would have to go and get it and, send it to me, whatever, for my clients. So anyway, so I never keep originals. I give them all back. So however you feel is the safest way, because sometimes you'll need the original. Sometimes you need copies and stuff like that. So I always give you the original because the original is what I want to say. And I never staple the original because you know how it goes with taking that staple in and out. It wrecks the paper. Put a little paper clip. So it's really up to you. Keep it in a safe place where somebody can access it closely. Excellent question. Okay. Ooh, let me take a drink here again. Well, I go to a will. A will versus a living will. Living will, remember, my body. I'm alive. What am I going to do with it? A will is I'm gone. I've passed away. Now what's going to happen to my things and stuff? My things and stuff. What are my things and stuff? Anything that I own, anything from my house to my furniture to my little dog Snoopy. Can you imagine? I don't even know who would take. So I know lots of people that would take Snoopy. Poor Snoopy. He just sleeps all the time. He's like 11 years old. Anyway, my dog, my house, my car, my money, my wedding ring, whatever. Where is it going to go when I pass away? That's what a will is. It directs where my stuff is going to go. Now, understand the will has to do with items that have to pass through probate. Remember, I spoke about the life insurance policy? That doesn't need to pass through probate. It should not pass through probate because you should be able to just put a beneficiary on there. When you pass away, that beneficiary contacts the insurance company, provides identification, maybe fills out a form or something. I don't know, whatever the criteria is for that. And they just issue a check. No probate, no nothing. It doesn't even need to, it doesn't go through the will. It doesn't do anything. So you can even put beneficiaries on bank accounts a lot of times, maybe the more the bigger banks. I'm not quite sure about the smaller banks, but the bigger banks, you can put on your bank accounts TOD, POD, or ITF, transfer on death, payable on death, in trust for. So that means they have no ownership to the account while you're alive. But once you pass away, they can go to the bank, they can present identification, proof of death, whatever it is, and then that account is now theirs. It's just like a beneficiary. Doesn't have to pass through the will, doesn't have to do anything. These are the kind of things I go over during my consultation so that we can cut down on the need for anything to go through probate. Now, your home, a lot of times, you can maybe do a life estate. A life estate is where you live in it, but there's a remainderman or a beneficiary that gets the home. Here in Florida, we call life estate or labor deed. In Minnesota, they call it beneficiary. And the only reason I know, because of course I have family in Minnesota. So, I get this crash course every once in a while about law in Minnesota, but I'm not licensed in the state of Minnesota. I just want to do that precursor there. So anyway, so a will directs where things go. Also, what a will does is it appoints a personal representative, somebody that we appoint to make sure that things are distributed. And that will, think of it, I always think of it as a will becomes a living, breathing thing because that's what's going to direct what happens. So it's kind of like me talking from the grave, right? This is what I want. This is what I don't want. This is all that. That will, for things that have to pass through the will, we call it into probate, and we have to file a case in court. And so court will require an original will. And if you can't, you've looked everywhere, oh my goodness, all these papers, and you can't find a will, you have to file all these documents. You have to get the original witnesses to sign affidavits or come into court and testify that they did see the original will. It's this whole big thing. And that's why I said, I never keep the original because I don't want, these are your documents. This is your life. I want to make sure you have what you need in the event that something happens, that you're not trying to figure out where I am or what I'm doing, or maybe I've moved to Spain now and, everything, you can't get a hold of me and the stuff's laying in my garage in the United States. I give it all to you. So the will appoints a personal representative. Now, let me tell you a story. My many stories from the nursing home. We had a bunch of children. I think there were 4 adult children. When she was alive, mom, she had appointed one of her children, let's say son Jimmy, to be her power of attorney. But in her will, she appointed her daughter Linda to be her personal representative. And that was her choice, completely 100% her choice, because she was able to make that decision. She was competent. She executed her power of attorney, her living will, her healthcare surrogate, and her will. Perfectly fine. It's perfectly fine until somebody starts fighting, right? So guess what? Linda and what did I call him? Jimmy, were fighting. So Jimmy came in with his power of attorney and said, I have, because mom had passed away now. It was just shortly after she passed away. Came into the nursing home wanting all this information, saying, I have power of attorney. And we had to explain to him, power of attorney is null and void when mom passed away. It is no longer valid. We can no longer honor it. Nobody will honor it because there should be a personal rep. Here in Florida, we call them personal representatives. In other states, they may call them executrix, whatever, it just depends on the state. Here in Florida, we call them personal representatives. That personal representative now has taken the power from the power of attorney and now has that power to be able to, file the case in court, get appointed personal representative, and start dealing with the assets and liabilities. Hi, Michael. Good afternoon, Miss Sterling. Good to see you. Great to see you too, although it's only a picture. I'd like to ask you, can you have more than one healthcare surrogate in Florida? Most definitely. You can have co-healthcare surrogates. You can have co-power of attorneys. You can do what you like. Or if you don't want to do that, I have people that appoint all their children, three, four, five children, which can be kind of challenging at times because then they got to all agree. Hopefully, they all get along well and they can agree. Or what I often suggest is alternatives. Okay, with any of these power of attorney, healthcare surrogate, and a will. Okay, Here's your primary power of attorney, healthcare surrogate, personal representative. If they're unable, maybe they're incapacitated or unwilling, maybe they're like, I'm really busy. I can't deal with this right now. It's too much for me. Emotionally, I'm just drained. Then there's an alternate. Okay, if Jimmy can't do it, then Linda will do it. If Linda and Jimmy can't do it, then Susie will do it. I usually tell my clients, let's do three deep. Anything more than that, you're just going, 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 going. So, but at least three deep, because by three deep, you should be able to, find somebody that's able to do it. So that's what I would suggest. You can always do co if you have two children and you don't want one to feel bad or whatever. And that, you sat down, you talked to them, they've agreed to everything, all of that. You can have co, where I would put language as an attorney, I would put language in the document saying they can work independently of each other, because otherwise, what do you have? Let's say you have a healthcare surrogate, the doctor's calling, looking, okay, here's a healthcare surrogate. Oh, there's co-healthcare surrogates. I got to get permission from both of them. And let's say you're on vacation in Ireland and the other one is, on the beaches of Mexico and they can't get a hold, or maybe they can get a hold of the one on the beaches of Mexico, but they can't get a hold of the one in Ireland. So that means they can't do anything because it's co. So I always put in there that they can work independently of each other. So Jimmy can make a decision. If they can't get a hold of Linda, then Jimmy can make the decision, or they can get a hold of Linda, but they can't get a hold of Jimmy. That one of them can at least make the decision, especially if it's an emergency. You want to make sure that somebody can make a decision if it's an emergency. So if you do have co's, to make sure they can work independently, make sure you talk to them, make sure they understand, they get it, they agree to that, and they're on the same page as you. So excellent question. So, Jimena, I think that's how I say it. What a beautiful name. Good afternoon, Attorney Sterling. Are the healthcare surrogates for children always the parents, or is there an exception? I can tell you here in Florida, and you have to check the law in your state or country, parents are the natural guardians of their children. I do not, if I have a child, I don't have a child who's under the age of 18. Mine's going to be 25 this year. Yes, I'm old, as I keep telling you. But if I had a child under the age of 18, the doctors are always going to come to me because I'm the natural guardian. If that child, if I'm dealing with the child's money, I'm the natural guardian. Of course, there's exceptions to that. If the child gets a settlement for whatever reason, it has to be accounted for. If they get life insurance benefits, those have to be accounted. You would have to apply for guardianship of the property to be able to manage that property, because they don't want parents saying, well, I'm the natural guardian. Oh, rad, windfall, and spending that money. So they do make it accountable if there's something in that aspect. But you are the natural. As far as making medical decisions for your underage child, your minor child, you are 100% the natural. You will do it. You will make it. They will not ask your 9-year-old, okay, little Susie, do you want to have your eye surgery? They're not going to do that. They're going to come to you as a natural parent. So excellent question, though. And that leads me off to, that would be a good topic to talk about next month regarding settlements for children. So anyway, so excellent questions. You guys have awesome questions. I'm so excited. Again, a will. So we're going to kind of finish off with that will. The will is something that deals with your things and stuff. Things and stuff, things and stuff. Think of that. Your living will, body, body, human, human, body, body. So things and stuff, how I distribute them. You can distribute your assets any way you want. If you don't want to give them to your children, you need to put that in the will, though, because your children, children can come and fight. If you want to leave it to a charity, what did I hear? I heard the other day that somebody, I can't remember what her name is, some very rich woman left $2 million to her dog. Do you imagine I leave all my money to my Snoopy, my dog? Oh, God bless him. He'd love that. Anyway, left $2 million to her dog. and left some piddly amount to her grandchildren. Well, she could do that. She left it to the dog, not necessarily to the dog, because he can't leave it to the dog. Dog is in Florida personal property. It's like my glasses. But leaving it in trust and appointing somebody to dole that out for the dog's needs. I'm sure that dog ate very good dog food. Anyway, a will, you can distribute it any way you want. Now, does a will guarantee that people won't fight? No. If people are going to fight, people are going to fight. People, if they want to fight, they're going to fight over $1 or they're going to fight over 1 million. They're just going to fight. But if you have everything written down, again, think of the document as a contract. This is what I want done. This is how I want it done. The court's going to really look at that and deal with that. And that's what you wanted. It's a contract. You signed it freely and voluntarily. Here in Florida, we have several attestations we have to attach to it, blah, 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 to make sure this person was able and understanding. And there's witnesses and there's a notary and everything. Another drink. I'm sorry I'm taking so many drinks. I've had this little kind of cough, so I'm trying to prevent myself from coughing. Anyway, so that's what a will is. And a will, like I said, it trumps a power of attorney. Once a person is away, that personal representative. But now, as a personal representative, even though you're named in the will, that doesn't give you power to go out there and start doing things. You have to have a court order appointing you that personal representative. And that's why you have to file in court for what we call a probate. And I'll talk about that next month. I'll go into detail. That'll be my topic for next month. So kind of as a recap, again, we spoke about power of attorneys. We spoke about living wills. We spoke about healthcare surrogates. We spoke about wills. All of those are documents that help you, how do I want to say, make sure that you're taken care of. Make sure that everything will be okay, hopefully, for the most part, for you down the road if something should happen to you. I have to say, when I first became an attorney, I did all these documents. Yeah, I did all of them. There, in fact, I found them. Isn't that terrible? That's really terrible. I know. I found them in my desk drawer at home. Oh, here they are. They need to be updated. I know I always use my parents. God bless them. You know, I love them. I love you, mom and dad. Anyway, they had their documents when I first became an attorney and I went to them. Okay, well, what do you have in the will? Well, we haven't done it since you were kids. We have guardian for you. Well, yeah, I don't need a guardian anymore. Yeah, I'm not a child. So that's when I had them redo it. So it's good to always, look at your will every couple of years and say, okay, let's kind of update it. Maybe you were giving something to your cousin Judy and cousin Judy passed away. So you want to update it. Okay, well, who do I want to give cousin Judy's share to now? So you update, and we call that a codicil. We would just do a codicil, just correcting that one little part. We don't need to do a whole new will unless you want to, but we can just do a codicil, at least here in the state of Florida, to take care of that issue. So all of these documents are to make sure that everything is taken care of. You execute these documents when you're competent, when you're capable, when you fully understand, when you're entering into them freely and voluntarily, you know what you're doing. Nobody else can sign a power of attorney for you. Nobody else can sign a healthcare surrogate for you. Nobody else can sign a living will or a will for you. You are the only one that can do it. At least here in the state of Florida, I would assume that's how it is, but you never know in other states. So again, check with your own. Um, and these just direct what's going on. And again, like I said, it may not prevent fighting, but maybe it will cut down. Again, talking to the person you're appointing as all these, making sure everybody understands, having a sit down with your family and your loved ones and discussing these issues. A lot of people don't like to discuss these issues because they are, they're kind of sensitive and you don't want to think about the other person passing away, but we all do. And so it's a good idea to sit down and have these conversations. And just remember that we're here for you. If you want to call, you're here in Florida and you want to make an appointment and I can go over all this with you, just be prepared to spend a lot of time with me. We'll get to be close friends and we can go over all this and we can make sure that everything's taken care of. So again, I want to wish you all a prosperous, healthy, happy 2023. And I look forward to seeing you next month where we'll talk about probate. Okay? Take care and have a great rest of your day.